Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The court calls case 319A19-1 N. Ray A.L.L. Mr. Miller.
Thank you. Chief Justice, members of the court, Mr. Watford. My name is Jeff Miller. I'm from the Pitt County Bar. I have the privilege to represent the mother appellant in this case, who will use her first name, Susanna. We have a stipulated pseudonym for the single juvenile, Susanna's only child, and that pseudonym is Ann. When I refer to the juvenile, I'll use that pseudonym. This is an important case for a variety of reasons, some of which are obvious and apparent because it involves a termination of a constitutionally protected right of a parent. In this case, that parent, Susanna, is mentally ill and disabled by her mental illness to such an extent that her incompetency was determined and declared early by the judge in the termination case on his own motion at the time, and over the objection of Susanna. This case began in Davidson County, which, as I understand it, is in District 22B, the same district that the termination action began in Davie County. The underlying juvenile case started in Davidson County in July of 2015, and it culminated after reviews, adjudications and reviews, and permanency planning in a permanent plan that prescribed for the best interest of this child a guardianship. And that guardianship was established after a February hearing in 2015 by an order entered in February 2017, by an order that was entered in March of 2017, signed by Judge Myers. The guardians resided in Davie County, and a year later, without going back to Davidson County, in the same district, they initiated a private termination proceeding. So this is not an action brought by a government agency for termination of parental rights. That will be an important issue as I discuss one of the matters in this appeal. The three compelling issues in the case involve the rights of a mentally ill parent who requires accommodations, who has been active in doing all that they can to meet case plan requirements and to be as involved as they're allowed to be by court orders with their child. It involves the integrity of a decision by a district court in one county in the same district by a different judge, district court judge, on the same identical evidence that was considered by a judge in a different county in the same judicial district, that changes things and it essentially overrules the order of the first judge. And it involves the sufficiency of evidence, findings of fact, and the very application of the two grounds under A6, which you've heard some today, the dependency incapacity ground, and A7, the willful abandonment ground. It will be my argument to the court that neither of those grounds properly applies in this case. It was known early on at the birth of this child that Susanna was not competent. She was clearly incapacitated from any ability to independently parent. However, she was fully capable of having that relationship that parents like her enjoy with their children in this state routinely. And that is a visitation relationship, supervised or unsupervised as the case may be. Despite her incompetency and her mental illness, which was serious, the record indicates schizophrenia, bipolar disorder, obsessive compulsive disorder, anxiety issues, eating disorders, the full panoply of mental illness. On top of that, she's disabled and receiving SSI, so she is impoverished. She is at a stage of life where she doesn't have income and she didn't have the mental capacity to independently have custody of her child. She recognized that early on, but she did and gave everything that she had to be a parent to her child. When the Davidson County Court was faced with the decision of whether or not, because it had concurrent permanent plans, whether or not to terminate this parent's rights or to grant a permanency in the form of a guardianship that maintained her relationship with her child, that court, we say on the same evidence, determined that a guardianship was the permanent plan for this family. And as a result of that, Susanna was allowed to continue to see, visit with, bring gifts to, have communications with the guardians, have an involvement as best she could. In the underlying juvenile case, the indications are, as that social worker who testified at the termination trial said, Susanna did everything we asked of her. She complied with what they required, and they understood her limitations and they accommodated her. That's what she seeks in this proceeding to reverse the termination of her parental rights, is the appropriate accommodation of her disability, her mental illness, that maintains her parental relationship. In that focus, I say to the court, and I know that it's a unique argument in the framework of a termination case that I have made, that the Davidson County District Court judge on the identical evidence decided guardianship was the permanent plan, not termination of parental rights when that option was available. And that the Davie County Court, in a private TPR in another county with another judge, essentially ignored and overruled that permanent plan by proceeding with a termination of parental rights. And the issue there is that in the Davidson County case, there is a government agency charged with the responsibility of the best interest of children involved in these juvenile proceedings. There was a decision there that the guardianship was appropriate for this child. The guardians then circumvented the government agency as a party when they initiated a private action in another county. And the government agency had no say, no participation in the very case that they had spent 2 years in. And in the case that it appears Susanna was compliant and did everything required of her. So,
Mr. Miller, let me make sure I'm following you, at least as I understand the relevant statutory provisions. The consistency or lack of consistency of the termination with the permanent plan is a factor to be considered at the best interest stage of the termination proceeding. Is that right?
That's correct, Your Honor. But
there's nothing in the termination statute that I can see, and please direct my attention to it if I'm missing it, that precludes a termination even if the permanent plan is something else. Am I missing something?
Your Honor, I won't say you're missing anything. The line of cases that I've cited about one district court judge not being allowed to overrule another, and the authority.
Those cases are sort of general principles of law rather than termination cases for the most part, aren't they?
They are. But if you look at the statute, 1102 and 1103, the legislature considered the fact that there would be both a termination and an underlying juvenile case. And it talked about intervention and it talked about consolidation. It did not use the word shall in those statutes, but it was clear that if we have an integrated juvenile process, the underlying process is an important part of it. And so my position on that argument, and I'll make it quickly, Judge, because I believe you have honed in on certainly an appropriate concern. My point is that when one district court judge is faced with the identical facts, the identical evidence, the identical information, and has the option of a termination and says no, the permanent plan, because adoption is a permanent plan, and says no, the permanent plan is a guardianship, and that's what's best for this child, then that order cannot be undone in a private TPR in another county by another judge. The parent has no opportunity to contest the propriety of changing the permanent plan, except to litigate a termination action and litigate grounds before they ever get to a best interest, and they can head that off otherwise.
Mr. Miller, you mentioned the statute 7B1102C, which says when a TPR petition is filed in the same district in which there is pending an abuse or neglect proceeding involving the same juvenile, the court on its own motion or motion of a party may consolidate the action pursuant to Rule 42. Isn't that the exact situation we have here?
That is the situation we have here, Your Honor. And of course, it's not shall language, it is permissive language, and I recognize that. But the contemplation, and the court said in TRP, of course, that we have an integrated juvenile process, and that the code is this integrated series of steps that are connected. And so there was neither an intervention or consolidation in this case, but no one ever went back, and DSS was never allowed to participate in any way when, in fact, the juvenile judge in Davidson County said guardianship's the plan. If anybody wants to change the custody, they've got to come back here. And they changed the custody because termination eviscerates visitation, which is a form of custody.
I understand what you're arguing as a logical matter, but it just seems like the legislature has spoken on this issue.
I will defer to the court, and I think in both of those statutes, they do talk about the two actions, the consolidation of the intervention in those actions. And I would point out that the JM decision doesn't have any application in this case. It was cited by the A.L.L, because both of these counties are in the same district, and 1101 is not a county jurisdictional statute, it is a district jurisdictional statute.
I mean, the other question that I was going to ask you, Mr. Miller, you've said a number of times that the evidence was identical. Wasn't there evidence at the termination hearing concerning events that had happened since the entry of the permanency planning order establishing the guardianship?
If Your Honor will recall, in the underlying juvenile case, there was visitation, there were visitations that were missed, visitations that were made. The mental illness was identical. If you look at the findings in this case are mental illness findings. So I did not discern any substantial or significant difference in the evidence at all. The same mental illness, the same visitation, the evidence was compliance with the case plan in the same ways, only limited by her mental illness.
Was there evidence, for example, concerning your client's exercise of her right to engage in visitation quarterly after the entry of the permanency planning order?
The evidence that is apparent from the record are that she visited, she had basically four visits within the period of time. There is nothing that actually in the evidence that showed when those visits took place, except in April of the year, I forget the year right now, Judge, but in April.
I don't remember it either, so we're both on the same page there.
Essentially, there were 2 out of 4 of the quarterly visits. You'll recall this lady was granted 1 hour every quarter to visit with her children after guardianship was established, in this case, in 2017. And the evidence, the petition indicated there was a visit the month before the petition was filed. There was a statement that there was a visit in April of the same 4-visit period. So she missed 2 visits. There was some testimony about a hurricane and about her being committed for 3 weeks. There was no evidence that explained in any way or resolved the issue of the missed visits in a way that impacted her. And the fact of the missed visits were consistent with her mental illness and what had occurred in the juvenile case, the same evidence, the same kinds of information. So to me, it was consistent. It was the same kind of evidence, nothing new, nothing different.
I have just if I can just I just have a really quick question about 7B 1102C. When this petition for the termination was filed in Davie County, your client had the right then to move to consolidate, right?
I'm sure that there could have been a request for the consolidation. If you recall, she had one attorney who withdrew in the case. Another was appointed after the case was already ongoing. And she filed her own handwritten answer in the termination. But no motion to consolidate was made. And she could have, you're correct.
Counsel, when you speak of, if I may, when you speak of the fact that it was a different judge in a different county that conducted the TPR proceeding after the guardianship had been permanently established, at least as far as that last judge was concerned, are you saying that there was no way that another judge of the same district with the same combination of judges, both in Davie County as well as Davidson County, that another judge could not operate within that same rubric of the judicial officers in that same district, and somehow there was some insulation that there could not be another action board unless it was before that specific guardianship judge?
Of course, the cases I've cited would indicate that a different judge within the same county can't overrule a judge's decision in that county, even if it's an erroneous decision. And that's really what I was trying to tag into, which is they're in the same district. They're at the same level, district court judge. They have the same authority generally, but if one judge makes a decision on facts when faced with this identical choice, another judge cannot undo that on the same facts or evidence. That there has to be something new, substantially different for them to do that. That's the position that I've argued.
Was the guardianship a static situation where there had to be something different, or was this an evolution of a matter wherein you've got a guardianship that is established at one point, and then at some point in the evolution of the case, that therefore TPR ended up being filed?
Justice Morgan, clearly things can change and could impact the case. I mean, the guardians themselves could separate. There could be issues that undo the guardianship by statute, but that guardianship statute puts in place a fairly permanent plan in which those guardians are the de facto parents. And they manage the child's life completely, except as any rights are given to the parent. And in this case, rights were given by one judge on what I say are identical facts and taken away by another judge on those same facts a year or so later.
My inquiry is primarily stimulated by the fact that you say that one judge, quote, overruled, unquote, another judge. And yet, if it is not a static situation where the matter is exactly identical, then my wonderment is it technically one judge overruling another?
My argument is, in this case, under these circumstances, it is, because the facts didn't change the underlying mental illness. And when I would like to move to my next argument, which is this was a termination based solely on mental illness, not on anything else. If you look at the findings of fact in the case, the probably 11 of the 15 or so that might be relevant just relate this lady's mental illness and mental problems. And in that regard, I want to say that it is my argument that neither of these grounds apply in this private termination case, which distinguishes it. And Justice Morgan, I'll start, I guess, with the A6 ground, because you recently authored an opinion about A6 in my law partner's case. And in that case, which was a private TPR case, you talked about whether A6 even applied when a child was not in need of placement or assistance and was in a safe placement. In that case, the placement was with a parent, but the statute you cited said parent and guardian. So this child was in a safe placement with a guardian at the time the termination petition was filed. And for the same reasons that the court said that it would not apply in that case, it doesn't apply in this case. And even if you were to say that it did, the defect that it was apparent earlier that the court noted concerning the findings of the court, there was no finding about an alternative child care giver. There were, at the time of the hearing, which was in 2019, there was old evidence in the underlying juvenile case, but there was no evidence presented at all in this case about the alternative caregiver, and the burden for that was on the petitioners, and there were no findings in the court order itself on that. In addition, there was some evidence before the court that there was an approved by DSS, Rowan County DSS, a caregiver, a lady named Shelley Lee. And the court didn't resolve that issue. So under those circumstances, the A6 ground doesn't apply, number one, for the reasons stated in the KRC decision issued in July. And it's defective and deficient because the findings don't cover the alternative caregiver prong. And the evidence, this is not a remand case because there was no evidence. And Ray Charles and I are on board with this one in the case I cited. This is not a remand case because there's no evidence at the time of the termination hearing on that issue. The appellee says, well, mother got on the witness stand and testified and she didn't propose anybody. She didn't have the burden to propose anybody. The petitioners didn't ask her a question about it. There was no evidence. So that ground fails as a matter of law and cannot be remanded because there's no evidence for additional findings. Similarly, on the abandonment ground, As this court knows, and there are a number of cases, Justice Irvin has authored some, and a variety of judges, Justice Newby recently and others, have talked about what abandonment is. The willfulness for an abandonment is a high bar, purposefully. There's a short period of time, 6 months. To use Justice Davis's or Justice Morgan's, I can't remember right now, comment, but I remember reading it. That abandonment has to be tethered to conduct in a 6-month period, and you can consider conduct outside of that period to see what the parent's intent was. But without the a willful abandonment under the statute. But more importantly, if the court remembers.
Mr. Miller, would you mind repeating what you just said, because your audio went out for the beginning of the sentence you were just saying. I apologize for interrupting you.
I'm sorry. I'm not sure where I was.
Since I couldn't hear it.
The abandonment has to be tethered to the 6-month period in the statute. And there has to be something that indicates the abandonment occurred within that period, although you can consider time outside of that in deciding about the parent's intent. Here, there were no findings, none about that period at all. And more importantly, all of the evidence and even the findings, because one of the findings the court made, which I mentioned in the brief, was that the mother desired to parent her child. She simply was mentally ill and incapable of doing it. So the court in its order even recognized that desire. And the actions of the parent, according to the law, must be wholly inconsistent with any desire to maintain custody. There has to be a willful determination to forego all parental duties and relinquish all parental claims to the child. It's got to be a purposeful and deliberate conduct. And here, critically, you have an incompetent. And I have argued and stated that an incompetent is not capable of the willfulness, the high bar required by this statute. The court has said the willfulness under this statute is higher, requires more than the willfulness under the other statutes.
Mr. Miller, you didn't ask for time for rebuttal, but if you'd like some, you've got about 3 minutes.
I'll reserve the remainder of my time. Thank you, Chief Justice.
Yes, sir. Mr. Watford?
Good afternoon, Madam Chief Justice, members of this honorable court. My name is Christopher Watford. I am appearing today, privileged to be here today on behalf of the petitioners in this private termination of parental rights action. Please forgive me, and I ask your indulgence. They are also the court-appointed guardians pursuant to 7B-600. They're also the foster parents for this child while the case was going through the Davidson County system. So if I may inextricably interchange their roles, they are in fact the petitioners in this private termination of parental rights proceeding at the same time as being the legal guardians. The relationship between my clients and this minor child began when this little girl was no more than not quite 3 days old. They were instructed by Davidson County DSS to drive to the hospital, where they picked her up, wrapped her, and put her in a car seat, and brought her to their home in Davie County, North Carolina. That was on July 10th of 2015, and I would note for the record the child never moved from that home until the petition was filed in this matter on February 27th of 2018. What may lead to some of the confusion is that Davidson County, as a foster care DSS placement agency, has placements in various counties. And so while this child was in Davidson County DSS custody, the child was physically placed with the petitioner's guardians in their home in Davie County. And since that day back in July 10th of 2015, they have raised this child as their own. They have succeeded to resolve a heart murmur and other issues with the minor child. And it's out of this desire to become more than just guardians, to evidence their unconditional love in a way that is legally recognized, that they seek adoption. Mr. Miller alluded to it and was very honest and forthright in his opening about the mother's mental state. No one has more pity for the mother. No one has had more experience dealing with the mother than the petitioners in this case. And it's not out of any desire for humiliation. It again is out of a desire to make this child a part of this family. In fact, the petitioners are actually parents in every way that matters, but one. And they believe that their unconditional love requires them to seek to become legally recognized for the purposes of adoption, the parents of A.L.L. And if I may address the arguments that have come in turn, we believe that on behalf of the petitioners that we complied with every aspect of the law as it relates to the jurisdictional filing and prosecution of this case. To give you a timeline as we go through, the minor child was removed, again, July 10th of 2015, placed in Davidson County legal custody pursuant to a non-secure custody order, and then guardianship was awarded by Judy Myers, the district court judge, by subsequent order entered March the 29th of 2017. And then within almost a year thereafter, the petitioners filed this termination of parental rights action. At this point, if I could take you through the jurisdictional statutes that you have, there's actually a series of 4 statutes that are in play here that demonstrate that the guardian petitioners have filed and complied with all jurisdictional requirements. In strange fashion, we actually start with 1104, which gives us a common frame of knowledge that either a petition or motion can be filed. And in this regard, what we have is a petition for termination of parental rights, not necessarily a motion, but a petitioner has the right to, or an advocate has the right to bring both. Now, where we see motions typically talked about in our statute is in 1102 and 1103, where there is an existing action. And then just like many of the questions from your honors came, it allows for someone to intervene, to potentially consolidate, but those reference those motions or that TPR that was filed in the same district. The court had its options. At this point, it chose not to act on those options. So we started 1104, we worked back to 1103, and then we get to the jurisdictional statute of 1101. And that is plain. Jurisdiction lies with the court in which the child resides at the time of the filing of the termination of parental rights petition, and that's exactly what happened here. And did not leave the home of the petitioners, which is in Davie County, North Carolina. All but 3 days.
If I could just ask you a quick question, I think it comes at this point in your argument. Do you agree that In re JM has no application because in that case, because here both counties are in the same judicial district?
Thanks for your question, Justice Earls. I wholeheartedly disagree. And even if there is a difference, I see that as a difference without any real meaningful distinction. If we look at that, JM actually involved a situation where it was foster parents who resided in Wake County actually went back to Durham where the DSS action was. Under the misapprehension of law, that's what they were supposed to do. And in fact, adopting Mr. Miller's position. And what the result of the court was there was simply that no. 1101 says what 1101 means. Jurisdiction at the time of filing is where the child resides. Now, in addition to JM, there's another case that illustrates this point between districts, since that was specifically mentioned. And I would refer the court to In re DLAD, and I'll slow down and give that again, DLAD, and that involves a Surrey County civil custody order and a Davidson County, North Carolina termination. And so that difference is from Lexington to Mount Airy, as opposed to simply from Knoxville to Lexington in that regard. So I would again say that it is a difference, but I do not see that the effects or otherwise would render what happened here impermissible or improper. And again, that is what the petitioners, guardians have contended in our brief, and we still stand by. Now, one of the things that may make it complicated is that Davidson County nor Davie County is a one-judge, one-family court. So practically speaking, in the brief, I do outline it's one district separated by a river, but the same judges hear various cases. So if we go by this principle of a judge overruling another simply because they appeared in a later hearing and reached a different decision, that happened at the disposition, that happened at the review, that happened at permanency planning. You literally had 4 different judges weighing in on this family, and eventually Judge Wood was the one who, in the Davie County action, made the final decision on termination. Forgive me if I've overlooked anyone.
Mr. Watford, do you agree with Mr. Miller's argument that the evidence at the termination proceeding was essentially the same as the evidence at the permanency planning hearing?
No, I do not.
What's the difference?
At police court, the evidence of the permanency planning hearing did consist of the main theme, which Mr. Miller has developed, which is Susanna's mental health. And the bottom line is Susanna's mental health is not getting any better, and that can be shown and demonstrated over time. So in the course of the termination of criminal rights hearing, there was both testimony and there was also documentary evidence that seems to be overlooked specifically in this matter. So there was testimony about the mother's whereabouts, her declining interest in visitation, her struggles with ongoing visitation, as well as records from both the Davis County Department of Social Services and Monarch Mental Health Services from 2018 post guardianship award that referenced her continued inability over time to make those corrective changes to be able to, number one, suggest an alternative placement, formulate a support system, or do anything else other than simply attend visitation when she decided to. And so for that purpose, I would say that much more evidence was presented. It has common themes, I will consent to that. But when we talk about situations like we have here, a lot of times we want to punish a parent who's done wrong. Here we have a parent who is a danger to their child because they just can't get it. That's why we have 11A6 in our termination of criminal rights proceeding. And if she doesn't get better over time, that danger remains.
Before you move on to 11A6, let me just make sure I'm reading your brief correctly, at least by implication. I'm not seeing any defense in your brief of the abandonment finding. Is that a correct reading, or am I missing something?
No, I believe you are. That's a correct read. I've had a chance to consult with my clients specifically on this issue.
Okay.
In terms of what was to be the central finding, which had the proximal relationship between the 6 months, that doesn't appear at the conclusion of law, and it doesn't appear as a finding, whether it's an ultimate finding, evidentiary finding, whatever this court may classify that needed finding as. I would contend then that the evidence would support a finding of that nature and would be appropriate to remand on the abandonment grounds.
I'm sorry, did you just say that the evidence would support a finding of remand on abandonment?
No, if it pleases the court, I believe the evidence would support a finding of abandonment.
Okay.
Or at least the findings that would support abandonment if this court were to issue a remand on that issue.
All right, thank you.
Well, that in terms of the final arguments on the issue of jurisdiction, I think what was happening here and what was advocated by my right honorable colleague would actually put my clients in a Hobson's choice. Well, if they have to go back to Davidson and they violate JM, they violate the LAD. They can file where they're at, but then do they have to consolidate? And the thing that we see here in the statute is that none of those obligations are placed on petitioner. They comply with the statute, and again, referencing 1102 subsection 2, they have standing to file a private termination of criminal rights action, notwithstanding the involvement of DSS. And I would leave this discussion with one item for your honors to consider, and that is simply the old perspective that a termination of criminal rights petition creates a separate and new action. And I refer to that in the case of A.L.L. that has an interesting procedural background, because this is the case where DSS filed a TPR petition. It was initially reversed by the Court of Appeals because at that time defects and summonses were considered subject matter jurisdiction. And so DSS in the TPR action tried to file a motion to fix the summons. almost undercut the appeal. And the Court of Appeals rejected that, specifically saying, it's noted in the footnote in the brief, that there are two distinct actions. Therefore, DSS could not use its termination proceeding to go back and correct the defect in the underlying A and B. So it's good for public agencies, it's good for individuals. And the final point that I would make is our juvenile code is also written so that termination of parental rights happen with no DSS involvement at all. And so with that said, we respectfully contend to the members of this honorable court that the Davie County District Court had appropriate jurisdiction and was the appropriate venue, and in fact, the only legal venue, according to JM, that could have heard this matter. With that said, I do transition now into 11.11.86. I know many of you justices have already had some arguments or some questions on this. If it pleases the court, the operative section of the order that I might refer you to is actually on page 251 of the copy of the record that I have. And 251 starts with various findings in the mid-20s, and eventually at the bottom denotes separate findings for best interest. And so one of those findings in particular are finding of fact number 37. And finding of fact 37 traces a lot of statutory language you see in 11.11.86. In fact, I'll diverge here to mention that 11.11.86 involves two separate sentences. The first sentence of 11.11.86 is the ground that the parent is incapable, such as the minor child is a dependent juvenile, and the incapability will continue for the foreseeable future. Now, at first reading, we're all looking for that alternative child care arrangement. It doesn't appear in sentence 1. Well, it appears, but it's hidden. Now, sentence 2, when it goes on to talk about incapability, mentions at the very last all the various conditions, including organic brain syndrome, mental health issues, epilepsy, and then says, and lacks an alternative child care arrangement. So what has happened is if we go back to the first sentence of 11.11.86, we see that or is a dependent juvenile. And so we have to go back in our statutes then to find that connection to alternative child care arrangement. That connection is found in 7B.101, subsection 9, which is your actual definition for dependency. And forgive me if I blacked out there for just a second, Your Honors.
Well, ironically, isn't the alternative care arrangement the guardians themselves, based upon what was found earlier by the judge that ordered the guardianship?
Thank you. If it pleases the court, I think that is incorrect on two different aspects. If it pleases the court, when we look at the underlying law that defines what dependency is in terms of lacking that arrangement, and as set forth in the brief, the emphasis is actually on the parent to provide an independent placement. Simply going along with whatever DSS orders, or what DSS does, or what the court orders, does not mean the parent exercises that control in making the alternative child care arrangement. And to the second point, if I might, there's actually case law that speaks to this. And speaks to this in the concept of a private termination of parental rights that occurred out of Mecklenburg County. In that case, which was in re KO, which was dealt with by the Court of Appeals, the biological mother essentially left her child with a friend of the family. After a while, the biological mother simply did not return, and so that friend of the family took it upon herself to basically achieve custody through a third-party custody action. And so therefore, there was a third-party custody order placing this mother's child in the legal custody of a friend of the family. And so she defended on the ground that there's a custody order. A court has spoken. This person is an appropriate child care arrangement. And the Court of Appeals, in its 3-0 opinion, rejected that outright. And the reason they rejected that was because the mother had no control or no emphasis in being able to affect that placement. She couldn't unilaterally undo that placement and achieve her own custody. At this point, in terms of that third-party custody, I equated in this matter to the guardianship imposed by the court. The mother didn't make that placement, as is required by many of our cases establishing dependency. And the second
let me interrupt you for a second, Mr. Watford. I wanted to ask you about that a little bit and follow up to Justice Morgan's question. Once the court order was entered in Davidson County, appointing your clients as the guardians, what authority did the mother have to make alternative arrangements for care of the child?
Certainly. Well, the mother had actually many different opportunities to suggest, to develop. I think the thing I regret is she was unable to do so over so many years. And
After the entry of the order in Davidson County, how far did her ability to do that go, since there was a court order of guardianship?
Well, with the court order of guardianship, the mother could always file under 7B 96.1 a motion for review to present to the court all the various independent individuals that would come forward to provide care. If the mother here would have reconnected with her mother from whom she was estranged, she could file again a 7B 96 motion, 7B 96.1 exactly, to have the court review that, take in that new evidence that would be available. So it's not as if the guardianship order would be the last spoken word. The mother does have options. She just never.
Well, what cause would she have to do that if the guardianship with the petitioners wasn't appropriate alternative arrangement was ordered by the court?
Well, and that kind of recalls us to read a little bit of the mother's mind. If she wants her child back, one of the things that she can do is actually bring a motion to modify or to dissolve the guardianship. And if the guardianship would be based on the fact she has someone else who is available, perhaps a relative who may have higher priority, or that she has improved herself. She's now not having the issues of schizophrenia. She's under medication management. Certainly she would rather have her child in her custody rather than just sitting back and let someone else raise the child ad infinitum.
Do you read the statute as requiring to establish the A6 ground for termination, that she has to have filed some sort of court papers to undo a guardianship that was duly ordered?
No, I don't think, in all fairness, Justice Hudson, I don't know that I would read the statute to say that. But I think in terms of filing court papers to undo a guardianship or to suggest someone else to serve as guardian or replacement is evidence that she is providing. She's taking that impetus to provide the alternative child care arrangement. Again, simply not accepting DSS orders or just going with whatever the court may order.
Well, let me ask you another question related to paragraph 37 of, as I understand your brief, you've argued that finding 37 is an implied finding of no alternative child care. So it is almost factor. And so even if it were a finding of fact and not a conclusion of law that implied what you say in your brief, you would agree that there's no specific finding of fact other than that regarding the existence of alternative child care.
Justice Hudson, I think, yes, I would have to agree. As I scan page 251 of that order, I'm expecting every other finding to see that specific information about a lack of alternative child care arrangement. So in terms of that official, and however it's classified, we're looking into evidentiary findings versus ultimate findings, and whether that's an ultimate finding versus an evidentiary finding.
Or a conclusion of law. Or it's almost wording as the language of conclusion of law number 2, in which case it doesn't have binding effect. It's subject to de novo review as an issue of law, correct?
I believe so, yes, Your Honor.
So is it your position that it is incumbent upon the parent, here in this case the mother, that the alternative child care placement or be oriented and occasioned by the parent in order to satisfy the statute to take it out of the grounds for termination of parental rights?
It actually is, and I would just refer the court to the brief I've already filed that actually establishes that. In terms of the various case law that we have, in CB and LH specifically speak to that, and they also speak to the fact that the well-intentioned efforts of a child placement agency at that point again do not count. That cannot alleviate the lack of an available appropriate alternative child care arrangement.
Doesn't there have to be a finding that the mother lacks an alternative child care arrangement regardless in order for this ground for termination to exist?
Yes. Now, I think your precedent speaks to that. And my argument to you is in this order, at that page 251, on behalf of petitioners, that finding 37, when it declares, when it finds at this point that the child is a dependent juvenile, that with it comes the finding of status to a dependent juvenile.
But I mean, I'm almost hearing you argue, and please tell me if I'm misunderstanding you. I'm almost hearing you argue that if I can establish that the child is dependent, then I don't need to make any finding of an alternative child care arrangement in this case, because there's no way that the mother could make such an arrangement, and therefore there's no need for such a finding. That sounds like your argument. What am I missing?
No, and Mr. Justice Irwin, I think at this point that is a statement of at least my first tier argument, which is the finding was made in a derivative fashion through finding 37, in that the child was dependent.
Well, assume that you're dealing with at least one literalist here who is bothered by the fact that there is no such finding. Then what?
Well, in the event there is no such finding, then I believe the remedy for this court would be to consider potential remand to the trial court. But even then, I would consider that the court may, at least under H&D, consider the fact that the evidence here is sufficient to show that there is no available appropriate alternative child care arrangement.
Well, of course, the existence of evidence isn't a substitute for a finding, is it?
May I ask you to repeat that, sir?
I said the fact that the record may contain evidence on a particular point doesn't excuse the trial court from the necessity to make a finding addressing the elements of the claim, right?
There's one, I agree with you in principle. There's one exception that I would make and just point out for your honors to consider. In doing this, there's a line of cases that talk about how neglect required a specific finding that the child was at substantial risk of harm or that the child was in immediate risk of impairment to be neglected under the statute. And that was the Ray case. This court adopted Judge Wynn's dissent in that case that said that if there's sufficient evidence in the record from which the finding can be made, there was no impetus to reverse at that point. So if the evidence in the record supported a finding in that case of substantial impairment or risk, then the matter would be affirmed. In terms of analogy here, we're saying that alternative child care arrangement has to appear in black and white in the order. And that was the same principle when it came to...
There has to be some finding. I mean, it certainly doesn't have to use the actual words of the statute, but there does have to be a finding that addresses the specific question of whether the mother has an alternative child care arrangement in some form, right?
Well, and Mr. Justice Irwin, I think that's where I can say that it would be preferred that there be a specific independent finding that says an appropriate available alternative child care arrangement does not exist. But given the order I have, and I was not trial counsel, of course, I'm counting on 37.
Right, I understand you. Thank you, Mr. Watford.
Yes, Your Honor, thank you.
What's your response, if any, to opposing counsel's position that in a situation such as the one here for the mother who is mentally challenged, that the most that she will be able to achieve would be a guardianship, and that in situations like this where a mentally challenged parent has done all that he or she can do to have involvement with a child or children, how should the court view such individuals in our society if they are not in position to find an alternative placement or to have any other way by which to continue a constitutionally protected right to try to be a parent?
Well, and thank you for your question, Justice Morgan. The court has spoken to this and spoken to it clearly when it said the primary interest in the polar star of these cases is what's in the best interest of the child. Here, again, no one knows this mother like my clients. No one's had to deal with the phone calls of visits. No one has offered their kindness to this mother like my clients. And when we look at it, do we delay permanence? Do we delay the unconditional love for pity of the mother? And I would say the answer is no. I wish there were more resources available because as a DSS attorney, as an agency attorney, I hate these cases. Again, we don't have someone who's a bad actor, neglectful, abuser. We have someone who probably, and I think this record supports it, was abused and abandoned by her own family when she was 20. It breaks my heart to have to do these types of cases and to have to do determinations as an agency attorney. But in all fairness, that's the reason why 1111A exists, is that it's better off for a child not to be in placement with an unsafe caregiver, no matter how innocent and how blameless that caregiver may be, that parent may be. Until there's an ability to increase that protective capacity in some way that's not 7B or the foster care system, I quite frankly don't know that we have a good answer for your question, Justice Morgan. I want to see.
If I can just follow up, because I didn't understand that those were the only two alternatives here. I thought that the mother wanted to continue the guardianship, but wanted to continue to have the limited role that her mental illness limits her to.
And Mr. Earls, I know that was a statement made. I don't know that was communicated to my clients. What my clients knew is what my clients deal with, which is a parent and every single day. And to become, again, those parents in every category, including the one way that matters in terms of this law, they seek adoption to make her a permanent part of their life, and not just someone to take care of, and when mom wants to stop by or is in the right frame to stop by, she can come and have some contact and then go on about her business. The child needs a parent, not a visitation resource. And if it pleases the court, I see that I am down to my final 30 seconds. Let me take the pleasure to say it's my privilege to be here advocating on behalf of petitioners here today. I thank the court for its very inquisitive questions, and again, look forward to your results.
Thank you, Mr. Watford. Mr. Miller.
As that constitutional rights, guardians are guardians. And our statute is designed to balance and to give proper accommodation when it can be done in the best interest of a child. You have not heard anything that 4 hours a year of allowing a relationship has disturbed or disrupted. But Mr. Watford indicates that apparently this is a parent who has been very active and who has been involved and who has contacted his clients. And they describe, or he describes, somehow she's a problem. That shows her desire to be involved, that she didn't willfully abandon. I would say that KO, certainly the case that he cited, has the provision in it as he described, but it did not discuss at all what Justice Morgan discussed, nor did it involve the circumstances that we have here, which, as the justices have noted, in a 7B 600 guardianship, the parent has little to no rights at all to undo the guardianship, to find an alternative caregiver. Justice Morgan's decision that a parent or a guardian is providing the assistance and the placement that a child needs that renders them not a dependent child is absolutely correct. And that's argued in my brief in a tangential way. But I also say that the case gets reversed because there was no evidence, none at the time of the hearing, that there was a lack of an alternative caregiver in the case.
Let me ask you a quick question, Mr. Miller. Sorry to interrupt you. I know you got very little time. Other than your client no longer having visitation rights, what would be the difference on a practical day-to-day basis between guardianship and adoption?
In terms of the relationship, a relationship is cut off completely. If you will recall, the record indicated that her family was having a relationship with the child also. The guardians were allowing the family to visit and see. She knew her extended family. There were 18 siblings of the mother in this case, in addition to parents. So all of that changes. Her extended institutional life and family changes completely. I did want to mention 35A, the incompetency statute. If you look at the definition of an incompetent adult, it is not a person who can willfully abandon. And I would encourage the court to look at that. I would also ask the court to read KRC in connection with the 7B 600 statute. And finally, I asked the court to look at the parable of the widow's mite. The person who gave all they had, they didn't have much, they offered everything. And that's what this lady did. She was only allowed 4 hours a year. Thank you.
Thank you to both counsel. Madam Clerk.
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court. All right, Jeff and Mr. Watford, you're
Got